The Roberts Court strikes again. This morning, the Supreme Court voted 6-2 to uphold a Michigan ban on affirmative action in the state's public universities. The decision affirms a Michigan constitutional amendment from 2006 that says state colleges and universities shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or natural origin. In a fiery dissent, which she read from the bench, Justice Sonia Sotomayor argued that without checks, democratically approved legislation can oppress minority groups. She added, "We ought not to sit back and wish away rather than confront the racial inequality that exists in our society. It is this view that works harm by perpetuating the facile notion that what makes race matter is acknowledging the simple truth that race does matter. In other words, merely acknowledging bias does not create it." The importance of affirmative action is born out of not just rhetoric, but it is also in facts. The New York Times today documents the effect that bans on race-conscious admission policies have had on an entire generation of American students. Michigan is one of 8 states to ban affirmative action in higher education. In the year after that ban went into effect in 2008, the percent of Michigan freshmen who were black dropped from 7% to 5%, even as the state's college-aged black population increased. In California, the numbers are even more distressing. In 1990, there was a 12% enrollment gap between Hispanic freshmen enrolled at UC Berkeley and the number of college-aged Hispanics in the state overall. That gap now stands at 38%. Either the Roberts Court is woefully ignorant of the effect their ruling will have on students of color, or they are perfectly okay with a society that makes it harder for those students to get a quality education at the very moment when we should be making it easier. Joining me now is the co-host of MSNBC's The Cycle and author of the MSNBC series Presumed Guilty, Ari Melber, and Georgetown University professor Michael Eric Dyson. Professor Dyson, let me start with you here. I thought Sotomayor's dissent was searing and absolutely spot on. It appears that the Roberts Court thinks by just acknowledging racial inequities, you create them.
Absolutely right. I think she was elegant. She was also eloquent. She was fiery in defense of a principle that is about true meritocracy, not the fake and false meritocracy that says we've acknowledged race in the past, but if we acknowledge it now, it will create the racial inequality that we seek to undermine. But if race has functioned as a demerit for so many decades and indeed centuries, it has to, at least for a while, function as a merit in order to take into account the very deleterious obstacle that prevented the flourishing of an entire group of people. Not only African-American people, not only Latinos, but women as well and other abled people. When you take that in aggregate, affirmative action, ironically enough, enables more people in the dominant culture to get a foot in terms of employment and in education than even African-American people. But if we talk about race specifically, affirmative action is not the belief that we will hand out to people who are not deserving a particular slot in school or at a job. It says that in the competition among relatively equal candidates, will give the nod to the historically underrepresented minority, because that in itself not only constitutes justice in reparation, but it also constitutes justice in terms of diversity and broadening the field of play in which we engage. So affirmative action is not handing out to somebody who doesn't deserve something. It's acknowledging that we have prevented the flourishing of these particular groups of people in the past and now seek to have a more just society by means of this legal instrument.
Ari, this is the decision today was not necessarily surprising for people who watched the Supreme Court and had a sense of where Justice John Roberts was going. In 2007, he was handling a case, giving his guidance on a school desegregation case where he overturned voluntary desegregation efforts in 2 school districts. And Roberts said, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. This seems to be the organizing principle. It allowed him, or part of that logic, helped to overturn Shelby versus Holder, which struck down Section 4 of the Voting Rights Act and has irreparably damaged access to the polls for millions of Americans. But this is, I think, as much as anything, the legacy of the Roberts Court.
This is a huge priority of John Roberts. You mentioned that famous line from the Seattle schools case, which was, of course, a case in the line of Brown v. Board of Education, a case that no jurist and no politician openly opposes, and yet that was a stop sign on that road from John Roberts saying you can't do that. You can't do that kind of voluntary integration plan. What's different about today's case, of course, is that, as you reported, it does not change the status quo of affirmative action across the country, which the court has upheld now twice. So affirmative action in a certain context is still basically legal.
But doesn't it put wind in the sails of those who would like to overturn affirmative action policies at their state universities?
What it does is give a boost to the political effort to ban affirmative action. Michigan being the central place, because this was where the original Grutter case came out of. The University of Michigan had a program here that had been tested, that had survived the court scrutiny, and then they went to the polls. And you mentioned the Sotomayor dissent. Her dissent is so interesting. She says, her view of what happened today, she says the majority of Michigan voters changed the rules in the middle of the game, reconfiguring the existing political process in Michigan in a manner that burdened racial minorities. What she's saying is not that you can never put something on the ballot through referenda. Of course you can. We know that if you've ever voted. But if you take something that was once done a certain way and was always fine as long as it had legacies or favoritism for donors or all the other ways that we have a Swiss cheese admissions policy, right? And the moment you say we want to do an equal opportunity policy, then suddenly you take it away from the Board of Regents, you take it away from local control, and you put on a flat statewide ban. And she says if you look at that in the context of political discrimination, that shouldn't fly. And that's what's interesting about her dissent. And let's be real here. You're not supposed to personalize the court. She is a minority on the court having this debate with her colleagues.
Who has been unabashed in her support for affirmative action policies and the importance they play. They play and they played in her life. Professor Dyson, you know, so much of this is happening, this debate is happening in and around college and university admissions policies. And as a professor, the debate over sort of racial justice issues and, you know, economic mobility in this country and who is afforded a sort of place at the starting blocks and who is not is very much up for debate. And I feel like, and I would love to know your thoughts anecdotally, you know, when these cases come up, I'm sure it spurs a lot of discussion on campus, and there's a real reaction to and a sense of indignation about decisions like this. What has the experience been like for you at Georgetown?
Well, you're absolutely right. First of all, people presume. When I was graduating from my undergraduate, Carson Newman College, going on with a full ride in a PhD program at Princeton, graduating at the top of my class in philosophy, graduate number 1, a white student's father came up to me and said, you know, son, you're not just going to Princeton because you're black. Well, look, the reality is, I guess all those hard-earned grades that I had made and all the hard work that I had done, in his mind, was not sufficient. I didn't, like some black conservatives, go, oh my God, because white people will think I've gotten a handout, I'm going to deny the legitimacy of the opportunity. Because those same white people didn't believe I was smart before affirmative action came. Why now should I reject the offering in light of that kind of rejection? So for me, it's very simple. That many white people are not asked to talk about their own privilege. The way in which affirmative action, as Ira Katz-Nelson at Columbia University wrote in a brilliant book, when affirmative action was white. We're pretending as if white Americans have not been the recipients of affirmative action from the beginning of this nation on down to the 20th century. When we talk about the GI Bill, which in majority strokes went to white Americans, there were a few other exceptions. It created the middle class. It provided opportunities for them to buy homes, to get educated, and to get an employment. That is an extraordinary degree of affirmative action. When Babe Ruth set the home run record, he was in an affirmative action class. He wasn't batting against the greatest ball players. He was batting against the greatest white ball players, because Josh Gibson and Josh White, who had hit 899 home runs, was not constituted as a fair opponent. So my point is simply, we don't ask white people to ask questions about their privilege. We don't ask the degree to which they've been the recipients of affirmative action in the negative in terms of preferential treatment, so that now, as Ari Melber talked about in regard to Sotomayor, in the middle of the game, you want to change the rules. When the rules benefited you, it was all good. When it didn't benefit you, now it becomes a problem. The burden of race still is borne on the backs of those who are African American, Latino, and others, and America must see that it has imposed that burden and must now share it in terms of reducing it.
Yeah, it's worth noting that legacy admissions have not been held up as for scrutiny, and those disproportionately
which are grandfather
or athletic access as well.
And I mean, well, the ripple effects that this has in terms of Black and Hispanic and people of color mobility, economic mobility in American society, not having access to a college degree is profound. In the last 6 years, white families have lost 1% of their wealth. Black families have lost 23% of their wealth. This is not the time to be cutting people's knees out from underneath them. Ari Melber and Professor Michael Eric Dyson, thank you very much for your time.
Thank you.
As a reminder, you can catch my friend Ari on The Cycle every weekday at 3 p.m. Eastern right here on MSNBC. Thank you for pulling double duty.
Noon Pacific.
Noon Pacific.